In this video, I'm going to explain the nuclear option in Florida shareholder disputes, judicial dissolution, and how it's used when partners reach a complete stalemate. And by the end of this video, you'll understand exactly when this remedy applies, how Florida courts decide whether to grant it, and what you can do right now to protect yourself before a dispute ever reaches that point. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I spent years helping business owners navigate the worst moments of their partnership. And I can tell you that shareholder deadlocks are some of the most destructive situations I have ever seen. What happens when two business partners hate each other so much that the entire company grinds to a halt? Nobody can make a decision, nobody will budge, and the business is just bleeding money. And walking away isn't an option because both partners have everything on the line. Now, there is a legal remedy for this. It's called judicial dissolution, and most business owners have never heard of it until it's too late. So let's get into it. All right, imagine this. Two partners own 50% of a company. They started the business together. Maybe they were friends, maybe they were family, and for a while, everything just worked. Then something changed. A disagreement over the direction of the company, a dispute about money. Maybe one partner suspects the other of self-dealing. It doesn't matter what started it. What matters is that neither side will give an inch. Now the company can't function. Board meetings go nowhere. Votes end in ties. Contracts don't get signed, and employees don't know who to listen to. Vendors start pulling back, and clients start leaving. This is what lawyers call a shareholder deadlock. And in Florida, it's more common than you'd think, especially in closely held corporations where you've got 2 or 3 owners running everything. Now, the tragedy is that the business itself might be perfectly healthy. The product is good. The revenue is there. But the people at the top are so locked in conflict that they're strangling the very thing that they've built. All right, so what is judicial dissolution? In simple terms, it's when a court orders a corporation to be dissolved, wound up, shut down, because the shareholders or directors are deadlocked and the company can no longer operate the way it's supposed to. Now in Florida, this is governed by Section 607, 1430 of the Florida Business Corporation Act. Under that statute, a shareholder can petition the court for dissolution under several grounds. The most relevant one for our purposes is deadlock. The statute says a court can dissolve a corporation if the directors are deadlocked in the management of corporate affairs, the shareholders are unable to break that deadlock, and the corporation is suffering or will suffer irreparable injury because of it. And there's another ground too. If the shareholders themselves are deadlocked and have failed to elect successors to directors whose terms have expired, that's also a basis of dissolution. Now here's what makes this the nuclear option. Dissolution means the company ceases to exist. Its assets get liquidated, its debts get paid, and whatever's left gets divided among the shareholders. The business is over. I know that sounds extreme, and it is. Courts don't grant this lightly. A judge isn't going to dissolve a profitable company just because 2 partners had a bad quarter. There has to be a genuine impasse. The deadlock has to be real, and the harm to the corporation has to be serious. So how does a Florida court decide whether a deadlock justifies dissolution? Well, first, the court looks at whether the deadlock is genuine. That means the shareholders or directors are truly unable to agree on fundamental business decisions. We're not talking about a minor disagreement over office furniture. We're talking about an inability to approve budgets, hire key personnel, enter contracts, or make any meaningful operational decision. Second, the court examines whether the deadlock is causing real harm. Is the business losing customers? Is it missing financial obligations? Are employees leaving? Is the company's value declining? The court needs to see that the stalemate isn't just uncomfortable, it's destructive. And third, and this is important, the court will consider whether there are alternatives to dissolution. Florida courts have recognized that dissolution is a drastic remedy. If there is a less extreme solution available, the court may prefer that route. For example, a court might order a buyout instead. One partner buys the other one out at a fair price. The business survives and the conflict ends. This is actually one of the most common outcomes in these cases. The petition for dissolution gets filed, it gets both parties to the table, and then a negotiated buyout happens before the court ever has to issue a final order. In practice, the mere filing of a dissolution petition is often the leverage that breaks the deadlock. Now, if you're finding this helpful, take a second and hit that like button. It helps more business owners find this information when they need it most. And if you want to stay informed on Florida business law, subscribe to this channel so you don't miss the next one. Now let's talk strategy, because if you're in a shareholder dispute, you need to understand something critical. Filing for judicial dissolution is not always about actually dissolving the company. Sometimes it's a tool. Sometimes it's a wake-up call. When one partner files that petition, it sends a very clear message, and it says, I would rather end this company than continue operating under these conditions. That changes the negotiation dynamic overnight. But there are risks. If you file for dissolution and the court grants it, you can't undo that. The company gets wound up, and you might end up with less than you would have received in a negotiated buyout. You lose control of the process. That's why this decision requires very careful planning. You need to document the deadlock. You need evidence of the harm, and you need to show the court that you tried other avenues first. And you need to understand your company's valuation before you walk into the courtroom. Here's something else most people don't think about. The best time to address a potential deadlock is before it happens. Now, if your operating agreement or shareholder agreement includes a deadlock resolution mechanism, like a mandatory buyout provision, a mediation clause, or a tie-breaking procedure, you might never need to file for dissolution at all. I've seen too many business owners skip over these provisions when they're forming their company. Everything feels great at the beginning, and nobody wants to think about the worst case. But that's exactly when you should be thinking about it. Because once you're in the middle of a fight, it's too late to write the rules. Let me leave you with this perspective. In Florida, closely held businesses are the backbone of the economy. Many of them are family-owned, and many of them involve partnerships that go back decades. When these relationships break down, the fallout is personal, it's financial, and it's often devastating to everyone involved, including employees, customers, and vendors who had nothing to do with the dispute. Judicial dissolution exists as a last resort to prevent a bad situation from becoming a permanent one. It's the court stepping in and saying, if you two can't figure this out, we'll end it so both of you can move on. But the smarter move is to never get there. Build your agreements with conflicts in mind. Include buyout triggers, include mediation requirements, and include valuation formulas. Work with an attorney who understands shareholder disputes before you need one in the middle of a crisis. Because here's the truth. Every business partnership will face conflict at some point. The ones that survive aren't the ones that avoid disagreements. They're the ones that plan for them. If you're dealing with a shareholder dispute right now, or if you want to make sure your business agreements are built to handle one, talk to an attorney who specializes in this area, and don't wait until the deadlock has already caused significant damage. Now, if this video helped you understand judicial dissolution and how it works in Florida, do me a favor and hit that like button. Subscribe to this channel for more content on Florida business law that can save you time, money, and a lot of headaches. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.